Good morning, everyone. Thank you for participating in this morning's status conference for docket numbers 2023-8E and 2023-10E. And these dockets relate to Duke Energy Progress LLC's and Duke Energy Carolinas LLC's 2023 Integrated Resource Plan. Everyone should have received a copy of the Notice of Status Conference in those, or have been electronically served copies. And the Notice of Status Conference references the Commission's order from January 25th, order number 2024-95, where the Commission stated in part, I further move that Commission staff continue to proceed with the status conference scheduled for February 2nd, 2024, which is the date and time previously scheduled and reserved by all parties. The status conference will allow all parties of record the opportunity to address any outstanding matters and to clarify any procedural issues or additional requests related to this case so that matters can be addressed early in the resetting of these dockets. Okay, I'm Jocelyn Boyd. I'm employed by the Public Service Commission. Several of my colleagues have joined me in the hearing room this morning for this morning's status conference. They include General Counsel Joanne Wessinger-Hill, Attorney Scott Winburn, Attorney Sandra Moser, our Commission Calendar Administrator, Ms. Elise Wilson. She's here to talk, parties of record for us to talk about the previously scheduled customer public hearing and the issue of scheduling any additional future customer public hearings. Our law clerks, Ryan McEachran and Jeff Congialdi, our live stream producer, Melissa Purvis, and our WebEx extraordinaire, Jackie Knight. Okay, so now I will, first of all, we will ask who's present for both dockets, and then I will ask attorneys Winburn and Moser to please proceed with the issues that have been noticed. And then the last issue we will talk about when the attorneys Winburn and Moser are finished are the customer public hearings. We will begin with docket number 2023-8E. Who is present and representing Carolinas Clean Energy Business Association?
Ms. Board, Richard Witt for Sasiba, and John Burns is on here also, as you see.
Good morning.
Good morning.
Good morning.
All right, then the Clean Energy Buyers Association.
Good morning. Elizabeth Haskins is here for the Clean Energy Buyers Association.
Good morning. Nucor Steel, South Carolina.
Good morning, everyone. Rob Smith, on behalf of Nucor Steel.
Good morning. Sierra Club.
Good morning. Isabella Ariza on behalf of the Sierra Club, along with Dory Jackie and Kate Huddleston. Thank you.
Thank you. Good morning. All right, South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, and Upstate Forever.
Good morning. This is Emma Clancy, and with me today is Kate Mixon here on behalf of CCLC's Boat Solar and Upstate Forever.
Thank you. South Carolina Department of Consumer Affairs. South Carolina Office of Regulatory Staff.
Good morning, Josh Ralston. I've got Donna Rainey and Chad Torrey in my office as well. We're having some technical issues, but mine seems to be working. Good.
Thank you. Good morning. Total Energies Renewables USA LLC.
Good morning, everybody. Court Walsh and Nelson Mellons for Total Energy.
Vote Solar.
Yes, this is Emma Clancy. Vote Solar is part of our coalition of clients, so CCLC,
Okay.
Upstate Forever, and Vote Solar.
Thank you. Walmart Incorporated. Okay. All right. Thank you, Ms. Eaton. Hold on a second. Duke Energy Progress.
Good morning, Jocelyn. Sam Walborn on behalf of Duke Energy Progress. Have Brett Breitschwert on the WebEx with me as well.
Thank you very much. Okay, so docket number 2023-10E. I'm just comparing my list. Mr. Witt, good morning. You and
Good
Mr.
morning.
Burns are present again for Carolina's Clean Energy Business Association, correct?
That's correct, Jocelyn. Thank you.
Thank you so much. All right, Clean Energy Buyers Association, Ms. Haskins.
Yes, ma'am.
All
Thank
right.
you.
Thank you. Sierra Club, let's see who I have over here. I have Miss Ariza and Miss Ariza, Miss Huddleston, and Miss Jaffe are joining you representing the Sierra Club.
That's correct. Thank you.
Thank you. South Carolina. Okay. Was that Miss Clancy or Miss Mixon representing South Carolina Coastal Conservation League? I'm sorry. I didn't write.
Yes, we're
You're both.
this is Emma Clancy and Kate Mixon is here as well. And
Okay.
we're both representing.
I'm sorry, Miss Clancy. I couldn't remember which voice belonged to whom. Okay, and then Miss Clancy, I'm also going to mark you present, you and Miss Mixon for Vote Solar, right?
Yes, that's
All
correct.
right.
Thank you.
Thank you. All right, I'm just going to call their name: South Carolina Department of Consumer Affairs, South Carolina Office of Regulatory Staff. Mr. Torrey, should I mark you, Miss Rainey, and Mr. Austin present?
Yes, please, Jocelyn.
All right, wonderful. Total Energies, Renewables, Mr. Walsh.
Still here. Yep.
Thank you.
Thank you.
All right, let's see. And then Walmart,
Still here.
Miss Eaton, still here. Thank you. And then Duke Energy Carolinas.
Sam Wellborn still here for the companies.
Thank you very much. And Mr. Brightschwert on this one too?
He is.
Okay. Hi. Okay. Excuse me, y'all, 1 second. Okay, we're back. Attorney Winburn. Oh, make sure. I didn't miss anyone, did I? I used my list from DMS. Did I miss calling anyone? Wonderful. Y'all ready?
Okay. Good morning, everyone. This is Sandra Moser with the PSC. Thank you all, first of all, for holding this date and being available to discuss the outstanding, we've got the procedural schedule, but any outstanding discovery issues in this case. So as you all know, the commission adopted the request to reset the 300-day timeline in this matter and the procedural schedule that was proposed by Duke. We have a couple different topics that I think we want to cover this morning, but what I'll start with is what was noticed for today, which is the January 24th letters, particularly the letter that was filed by ORS. And Duke did file also a letter on the 24th. And so we wanted to get just additional clarity on those two particular letters. It didn't appear that the Duke letter was necessarily responsive to the ORS letter that was filed. I believe they were filed about 45 minutes apart. And so today we just wanted to use this opportunity to give all parties really an adequate opportunity to be heard, especially in light of the fact that we didn't have an oral argument as originally planned. And of course, we're confident that you all can resolve any sort of outstanding discovery issues, but just wanted to be available for all the parties today just to make sure that there's clarity on that particular issue. So we'll start with that one. And whoever wants to chime in first, I'm looking at Mr. Wellborn. I don't know if he's prepared to go first or someone from ORS, either is fine.
Yeah, I'm happy to. And thank you for that. And thank you for hosting us this morning. Like you implied, I think sometimes it's good for us to have a forum so that we can talk through things. Yeah, as mentioned in our January 24th filing, we've accomplished the additional modeling that ORS had requested. That was filed as part of our Wednesday afternoon filing. I don't know, to the extent I won't speak to, whether other parties have had an adequate opportunity to review that filing, at least in a preliminary way. But fact of the matter is, we've done a lot of modeling. There have been a lot of late nights, and I'm proud that the companies have gotten it all done. it's been a lot of work. We've answered, in addition to the January 31st filing, answered a lot of discovery in this docket so far. And just to reiterate, one message, which is that January 31st filing is intended to be supplemental to what we filed in August with the commission. So we filed our IRP in August. We felt that met our burden of proof in the docket, but that the supplemental information would be useful both to parties and to the commission as they evaluate the company's IRP. And so I think all told, we've modeled 40 portfolios for consideration. We do have an updated preferred portfolio, which was part of our supplemental filing, and that's P3 fall base, as evident in our supplemental planning analysis and the other filings that we made this past Wednesday. So I'll stop there. I don't have a request. Just wanted to, again, thank y'all for hosting this and to reiterate that, we made a big filing on Wednesday. We got it done, and we look forward to, next steps in discovery as well as other parties filing direct testimony later this year. So thank you.
Okay. Thank you very much for that.
Do you want me to use the list that I have?
Yes.
Okay,
that would be
no
wonderful.
problem. Let me, okay. Let's start with Mr. Witt with Carolina's Clean Energy Business Association.
I think John Burns has comments.
Okay.
We have reviewed briefly in the couple of days we've had since that filing. I agree with Duke's attorneys that obviously a lot of work went into that, but I do think there'll be quite a bit of discovery related to those updates. I don't know that we have any concrete positions right now on how that should play out, but we do think that there will be quite a bit involved. So I'm gonna, if you don't mind, reserve the right to come back and comment, but there are parties that have more intense modeling to do, and I think perhaps their needs are probably primary here because they've got more modeling to do than we intend to do at CCEBA.
Thank you, Mr. Burns. Let's see. Mr. Walsh with Clean Energy Buyers Association.
Elizabeth Haskins, ma'am.
Oh, I'm sorry. I don't know why.
You're fine.
Did Mr. Walsh speak up today?
He is here on behalf of Total, but we are both on the CEBA pleadings.
Okay,
You're
I
not wrong.
apologize. I apologize, Ms. Haskins. Excuse me.
It's okay. CEBA is in a similar position as CCEBA in that we would kind of defer to those who are doing modeling and support those who are doing modeling in their efforts. We, anticipate doing discovery, but we won't be as involved as, say ORS and other folks who are trying to get the modeling done. So we would defer to them.
Thank you, Ms. Haskins. All right, Mr. Smith with Nucor Steel.
No additional comments. Thank you.
Ms. Ariza with Sierra Club.
Thank you. Sierra Club would echo the discovery issue that Mr. Burns flagged, and we do have some comments about the proposed scheduling of the hearing, but we can touch on that later, hopefully. Thank you.
The hearing with where the company presents, Ms. Ariza, and the interveners present, not the customer public hearing. You have comments on that?
On that, yes.
Okay. Yes, ma'am.
But also on the discovery timeline.
Oh, okay.
After the rebuttal.
Okay.
The rebuttal and serve.
All right.
Thank you.
Yes, ma'am. Let's see. Ms. Clancy with South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, Upstate Forever, and Vote Solar.
Yes, like the others, I'll just echo Mr. Burns' comments on the discovery schedule. And we, like Sierra Club, do I think would welcome the opportunity to talk about the proposed schedule later in the status conference.
All right. See, nobody from, let's see, Mr. Torrey, Office of Regulatory Staff.
Sure, Jocelyn, this is Joshua Austin. I was going to respond on behalf of ORS to this issue.
All right.
So ORS filed a letter back on I think it was the 18th. That was essentially our reply to our original motion for declaratory judgment. In that, we sort of briefly just mentioned that we would request that the commission require the companies to complete some additional modeling for their P1 and P2 portfolios, in addition to the information that the companies intended to file on their own for January 31st, which they did file in their supplement. And so then when we saw that there was not going to be any opportunity for oral argument, that's when we filed that additional letter on the 24th, just seeking to provide a little bit more detail in what we meant by that request. That's where we included some more specifics of what we would hope that they would do additional modeling on. And so that's just sort of the context there. We'll be able to work through this, we think, in discovery. We didn't need this in the supplement for January 31st, but we also don't want to be in a situation, where the parties don't really have an adequate and fair way to compare all portfolios, with some having additional modeling while others may not have as much or as robust comparison.
Thank you, Mr. Austin. Ms. Haskins, should I call on you for total energy renewables also? Or Mr.
No,
Walsh?
ma'am.
Call
Court
Mr. Walsh.
is here for Total Energies.
Okay. Mr. Walsh?
Hey, Jocelyn, good morning.
Hey, good morning.
No other comment from Total.
Thank you. All right, let's see. Ms. Eaton, do you have any comments on behalf of Walmart?
I don't have any comments. I would support what Mr. Burns said as far as other parties that may have additional discovery or modeling that they're doing, and having sufficient time for that. But I did have a question, and it kind of relates to the content of the two letters on January 24th. It looked like there is going to be some additional, or that there was additional modeling performed for P1 and P2, maybe as compared to P3 fall base, and a no carbon constraints modeling. And I wondered whether or not Duke had anticipated additional testimony on that modeling that I think was provided on January 31st, but maybe wasn't addressed in the testimony filing on January 31st. So I just wanted to clarify that bit. Okay. Because if that would be additional before rebuttal testimony.
Mm-hmm. Mr. Wellborn.
I'm happy to respond to that if you like.
Please.
Yeah, no, we have filed our supplemental direct testimony. We don't intend to file any further direct testimony. Again, happy to answer questions in discovery as parties have a need, and then we look forward to getting other parties pre-file direct testimony 5 months from now. So there should be there's a pretty good window there for any discovery that needs to take place. But we have no intention of filing further supplemental direct testimony.
Okay.
Thank you for clarifying that.
All right. Okay, I think everyone, I've called did I miss anyone? All right. Thank you. Ms. Moser?
Thank you, Jocelyn. Now that we've heard from everyone, I think that really has helped to clarify some of these kind of outstanding questions that we had from those two letters. It sounds as if many of these potential issues could be resolved through the typical discovery process. So I'm optimistic that we'll be able to do that. I did have a follow-up question to Mr. Wellborn. Your statement at the beginning about the supplemental testimony that was filed on January 31st. One question that staff had was, since this is supplemental testimony to the initial IRP August filing, would it be possible to provide an index or perhaps an errata sheet or something of the sort to help clarify which sections or provisions have changed pursuant to the supplemental filing in comparison to that original IRP that was filed in August? Does that make sense?
It does. We can prepare a letter to that effect.
Okay.
I'll leave it there. Yeah,
Okay.
my instinct is that our filing was supplemental and really intended to supplement, not to replace anything in the August filing. But
Okay.
I'll circle the troops and we'll confirm that and file something with the commission.
Okay. I think we'd really appreciate that. Just again, to make sure that we're clear on everything that has been filed since and how to compare those documents.
Very fair. Thank you.
Let's see. Did you all have any other? I know we've got. Yes. I know Jocelyn has additional questions as well. Okay. All right. If we, oh, yeah, okay. And that was who? Okay. All right. If we could go back to Miss Ariza from Sierra Club. I know that she had some additional comments, perhaps about the discovery timeline and the hearing, I think was what we heard. If we could flesh that out a little bit more. Miss Ariza, if you're available, or
Yes.
Anyone from Sierra Club.
Thank you so much. So Sierra Club would like to raise two issues with the proposed schedule for this proceeding. First, the issue of allowing enough time between the company's rebuttal and all the other parties' rebuttal testimony. Currently, the schedule proposed by Duke and approved by the commission has the deadline for parties to file rebuttal testimony on August 30th, just 2 weeks after the company's deadline to file rebuttal on August 14th. So to preserve interveners and ORS's discovery rights, the time frame between Duke's rebuttal and all other parties' rebuttal would have to be longer, or Duke's deadline to file responses to discovery would have to be reduced from 20 days to 10 days. So just to avoid placing an excessive burden on Duke, Sierra Club would suggest preserving the 20-day discovery turnaround, but changing the date to file rebuttal testimony to September 5th, which would allow the same number of days between rebuttal and rebuttal contemplated in the original schedule of this case. And this would, of course, impact the rest of the schedule. It would involve pushing the hearing out at least 1 week, potentially to the week of September 23rd or September 30th, to similarly allow Duke to serve discovery on interveners related to interveners rebuttal. And the second issue that we'd like to raise involves the dates in which the commission will hold public hearings. So public hearings were currently set, or were set by the original schedule of the case for March 18th and 19th, which would have been around 3 weeks before the actual hearing. So if the intent is for the public to be able to assess the IRP and perhaps read intervener testimony, then the public hearings would need to be rescheduled to early September, or in any case, 2 or 3 weeks before the hearings take place, if the intent is to maintain a similar time frame with respect to the hearings. Those were the two issues that we wanted to bring up. Thank you.
Thank you so much for those comments. Ms. Boyd, would it be okay if we did what we did earlier and just went through the list?
Mm-hmm.
Just want to make sure that everyone has an opportunity to be heard on those 2 points.
Okay.
And Madam Clerk, before we do that, instead of pushing down the hearing and getting closer to the deadline for the commission to issue and make issue an order to make a decision, please everyone share if we can move it up, as in any direct testimony is filed, direct testimony of all the other parties is filed earlier. The rebuttal timeline is moved up for Duke so that we can preserve and keep the exact same hearing date. Because that's where your time is going to be.
Okay. Mr. Burns? Carolinas Clean Energy Business Association?
Yes, ma'am. Thank you. I think the request from, as originally stated is pretty reasonable. And so I would support that. I have a problem with moving direct testimony deadline earlier, although I understand the impetus behind that request. The problem is there's a whole lot going on with a lot of these same parties in the North Carolina hearing in June and July. And so, when you called on me, I was trying to find my schedule from North Carolina for that. There's a number of issues in June and early July. Interestingly enough, the way it's currently falls, all those deadlines fits pretty well with the North Carolina hearing. If you start moving them around, or making them earlier, then they start to conflict, and it'll be up to us to deal with those conflicts. But if we can avoid them on the front end, that's always preferable. But I do think the argument about there being insufficient time to issue and respond to discovery for the server rebuttal deadlines is a good one, and one that should be addressed.
Mr. Burns, this is Joanne Hill again.
Yes, ma'am.
Just to see, can you, and we can come back to you, give you time to think, what can be, without moving the hearing date, what other options would there be to put time into the schedule?
Right. Yeah.
That's what we're trying to find out.
There's the rub, right?
Yeah.
I'll see if I can come back and make a suggestion. I'm trying to compare the two schedules right now. I don't want to delay any other comments.
I'd like an opportunity to chime in too, if I may, Ms. Boyd or Ms. Hill.
Okay.
I realize it's a little out of turn, but the schedule that the commission approved was one proposed by the companies on January 16th. No party filed a response to that proposed schedule. I think SACE and CCL and that group maybe filed something to the effect of they wanted to look at it and then never filed a subsequent response. Parties had an opportunity to respond to that. The commission approved the schedule that we proposed, with respect to counsel for Sierra Club. It's and I get the intent of this meeting. It's just kind of frustrating, because we worked so hard to meet the January 31st timeline that supports the schedule that we proposed. No parties opined on, and the commission has now approved. It seems a little late, frankly, for my chair to start retrading or changing things that the commission has approved based on filings from the parties. So, like Mr. Burns, everything's connected. All these schedules sort of twist and tie with each other. We've got, a fuel hearing, I think, around that time that will follow the IRP hearing for Duke Energy Carolinas or Duke Energy Progress, one of the Duke companies. It's just, once you start sort of jiggering things around, it can have unintended consequences. And so, anyways, I appreciate you allowing me to speak out of turn, but, it's just tough to keep having to go back to the drawing board when you've been working on something for weeks and weeks and the commission approves it and you finally have some finality and everybody's ready to move forward. And then you've got a proposal that sort of tugs on the rug a bit. So anyways, I'll stop there, but appreciate Mr. Burns' position. I agree.
Okay, so just so everyone knows, on our calendar, the Duke Energy Carolinas fuel adjustment proceeding is scheduled for September 24th.
I'm sorry, one quick addition. We could be willing to work with, so in dockets where the timeline is squished and, you have less than 20 days before the next milestone and discovery's been requested, parties frequently, including the companies, will answer discovery on a shorter timeline. I don't want to make any, sort of commitments without having consulted with my client, but it's very typical for us to respond to discovery in certain circumstances where, the responses are needed on a shorter timeline. So that's another avenue I think that we could theoretically be flexible on, again, without making any commitments and not having consulted with the client.
Do you want to go back to Ms. Ariza with what Mr. Welborn just said about the discovery, maybe possibly answering discovery earlier? And if so, I don't know if the schedule, if she's still of the opinion, the schedule will need to change. Ms. Ariza?
Thank you. That would be, I think, a great solution if Duke could answer discovery on a shorter timeline. I would just note that the same decision that proposed, that adopted the proposed schedule set this scheduling conference. So that's why we believe this was the right opportunity to bring these issues up. But I think that would be a good solution. Thank you.
Ms. Moser, you want to say?
I guess if we can keep going. Down
Oh, okay.
the
I didn't know if you
list.
wanted to ask Mr. Or I'm just talking to you.
Yeah.
Do the parties want to come back later after Mr. Welborn's been able to discuss the discovery response issue with his client to say whether that's firm that they can answer earlier within 10 days versus 20?
Mm-hmm.
I'll continue the list, but
Yeah,
think about
I think
that.
we
What you
can
want?
keep that conversation going.
Okay.
Yeah.
All right. Ms. Haskins for Clean Energy Buyers Association.
We don't have any further comments. We think a shortened discovery response deadline would be a great solution.
Thank you. Mr. Smith, Nucor Steel.
No comments. Thank you.
Ms. Ariza. Ms. Ariza, do you have some more comments
No,
at this
ma'am.
time? Okay,
No
I
more
just want to make sure I didn't skip you. All right, now, Ms. Clancy for South Carolina Coastal Conservation League, SACE, Upstate Forever, and Vote Solar.
Yes, we think a shortened discovery timeline would be an option. I'll also just note, I think under the original schedule, the company had 41 days to file rebuttal testimony, and interveners had 21 days to file surrebuttal testimony. And under the revised schedule, the company has 44 days to file rebuttal testimony, and interveners have 16, I think. And I don't know, one solution could be to just maybe move the company's rebuttal a few days earlier to allow for more time. But I also think if it would be simpler to just, for the company to provide expedited discovery responses, we would be fine with that solution as well. And I certainly don't want to overcomplicate the schedule. So.
Thank you, Ms. Clancy. Let's see. Mr. Austin, do you want to speak on behalf of ORS this time?
Yes, thank you. So ORS is okay with the procedural schedule that's laid out in the directive. We would not be in favor of moving the direct testimony up any sooner than it currently is. And that, just to circle back on a previous issue to make sure that we have clarification here, ORS still has its outstanding request for the additional modeling from its January 24th letter. And we would still hope to either have the company's commitment to do that additional modeling or a commission directive for them to do that additional modeling by that February 29th date. Thank you.
Thank you. Mr. Weber, do you have any response at this time? You don't have to about his.
I can. We're happy as related to the discovery timing issue to work with the parties offline and get to an agreement on that. I don't want to get us too bogged down here. Okay. I personally feel strongly that, we made our proposal as to the proposed procedural schedule. No party responded. The commission approved it. Gosh, let's be done with that, right? But I also understand council's concern about the discovery timeline, and I feel certain that we can work something out offline on that issue. So I say that in good faith, and I mean it. As to Council for ORS's note about its January 24th letter, as I communicated at the top of this meeting, I don't know whether parties have had an opportunity to look at our January 31st filing. We included the modeling that ORS had requested. and it's January 18th letter. You know, any sort of more detailed, quote unquote, more detailed request included in its January 24th letter, ORS will have to do its own evaluation as to whether what we filed matches what they're looking for. You know, and again, I don't know whether they've had an opportunity to do that yet or not. The discovery process is available to any party that wants information that we can provide. Yeah, I think I'll leave it there. You know, it's unclear to me whether they're asking for something new or whether they just haven't sort of dug into our, you know, not insignificant January 31st filing. And, you know, I don't mean to imply that they haven't done their homework, because it's a big filing and, you know, it's only been a day and a half or so. Yeah, and I don't know if ORS is in a position, and not to put them on the spot, but to say whether there's anything missing from that filing or not. I will say we did include, you know, the planning reserve margin element that they had mentioned in their letter. We don't drop below the commission approved 17% planning reserve margin. We grow into the 22% planning reserve margin between 2027 and 2031. So that to me is a check mark. There is, in our view, significant you know, varying modelings between the low, base, and high forecast. So we think that's a check. In terms of mini-max analysis, there was analysis included in our August filing, and the modeling that we've done as part of this January 31st supplemental filing is consistent with that modeling. So again, if ORS, you know, after they've had an opportunity to review our January 31st filing, if there's something they want to request in the discovery process, they're absolutely welcome to do that. Thank you.
Thank you, Mr. Weber. Mr. Torrey, was that Mr. Torrey? Did you? No, Austin. Thank you so much. Mr. Austin,
Yes.
Are you okay at this point with Mr. Welborn's response? Did you have anything you wanted to add or want to add?
Yeah, I don't think this will be solved today on this status
All right.
conference. So
Okay.
you know, I think we're okay.
Thank you, Mr. Austin. Okay. Mr. Walsh, Total Energies Renewables USA LLC.
No comment. No further comment from us.
Thank you. Let's see. And Ms. Eaton with Walmart.
Sure. You know, we and the other parties, I think, can offline work with Duke on the scheduling issue. But something that Sierra Club had raised was moving the public hearings to September. I think we kind of missed that part, but I think that would definitely be in order, moving those.
Okay.
And we just hadn't I don't think we'd gotten there yet. We were
Yeah.
trying to
Okay,
resolve
sure thing.
Right.
but anything else?
Yeah, I think because Mr. Welborn, we switched order. So I think you've spoken. Okay, did I miss anyone? Spoken so far. You have some more speaking, I'm sure.
Jocelyn, before we leave the information requested in the January 24th, 24 letter by ORS that Mr. Austin and Mr. Welborn were discussing, is it possible that y'all could get together, and whomever else would be included in that, to come back and give an update to the commission, let's say by sometime next week, maybe next Wednesday, to let us know if, you know, how's it going, or if some of it's answered, not answered, all answered, just so the commission will know what it needs to do to address that issue raised in the January 24th letter. Does that sound reasonable?
Additional modeling.
Yes, that'll because it sounds like Mr. Austin with ORS and Mr. Welborn, they need to look at it, and they haven't really had a chance to look at everything to see if everything is covered or not covered as listed in their letter by the January 31st filing.
So you want to ask Mr. Austin first? Is that enough time since they have
Or
to?
give us
We can provide an update on Wednesday.
Okay. All right. Thank you.
Thank you, Mr. Austin.
And I don't know if it would help. I know Mr. Welborn had mentioned that Duke was willing to provide some sort of document to kind of give an explanation of what's replaced, not replaced, or supplemented, or stricken from the original filing to what was supplemented or filed on January 21st. And everyone may need that before they can respond. Or if, and Mr. Austin, if anyone, including Mr. Oborn, if y'all need additional time, please let us know. But we'd try to have some clarity or a little bit more information, at least by Monday, the 12th, I do believe. If possible.
We can accomplish that
Okay.
on our side.
So, sorry, just to clarify, so you would like an update by the 12th, not by Wednesday the 7th?
Well, if you can do it by Wednesday, that would be wonderful. If you need more time and you can't make it by Wednesday, we'll say the 12th is fine. Because you may want to look at, I'm not sure how long it'll take Mr. Wellborn with the Duke companies to provide kind of an indexing or index, whatever you want to call it, or letter explaining what was replaced, not replaced, or supplemented, however you want to say it, by the 31st filing, or what matches what, or what's doing what on it. So you can look at the original filing, because it appears, Mr. Wellborn, please, I'm not trying to put words in your mouth or inaccurately paraphrase what you said, but it seems like the information on 31st is supplementing, not replacing, but adding to what was filed in August, correct?
That's right, but I also understand and hear your request for an index, and so if there is such an index to be produced, we'll get it in, and if there's not, we'll get that in as well. But I hear the need, and we'll be responsive to it.
I think we would like an index. I think everyone would like an index.
Okay.
And if you can kind of give us a time frame when you think you could do that, sooner is better.
Understood.
ORS also needs it to assist them, I would think, and every other party as well. And it might even help with some discovery issues we don't know.
Certainly by the 12th. I don't want to overcommit us because I'm not exactly sure the scope of work that would involve right now. So.
Mr. Wellborn, I was just looking over your January 31st letter, and you do have, it's the second to last paragraph, you state that the companies also plan to provide all supporting work papers to parties via the ongoing discovery process on or around February 9th, 2024. So I just wanted to mention that date because that's also within that time frame. And I also wanted to, if I can ask you, that's the correct date, the February 29th, not a later date for those work papers?
Yes, and to be clear, work papers would include, for example, underlying spreadsheets and other sort of pieces, parts that contributed to or supported the modeling.
Okay, thank you for that.
Okay, so I think we're ready now just to talk about the customer public hearings. So everybody, we didn't really address, and I don't think the commission's order did, the customer public hearing that was previously scheduled for March 18th. And I think the commission staff received the pre-registration of at least one individual for that hearing. And Mr. Wilburn, if I may just ask you, as I'm thinking about this, we anticipate once this schedule is finalized, another notice being issued to customers. I don't know how else to handle the notice for the new merits hearing. And then, the original request for customer public hearings to be scheduled in the two dockets.
Trying to remember whether the public hearing, it must have been part of the original notice that we sent out.
It was. Ms. Purvis, would you display what's on the document camera, please? So this is the second page of the original notice. And so, Monday, March 18th, and then we also internally reserved the 19th. So one question is the parties' opinions on whether the commission should still open the hearing for the 18th, to hear from that individual or individuals. The last I checked, there was one. I think I'm correct. I think we're interested in the party's thoughts on that. Okay.
I don't know if you're looking for live thoughts or not.
Yeah, we can start with you, and then I'll go down the list. I'll review the list again, Mr. Welborn.
Well, I mean, the fact of the matter is we have filed our IRP. We've now supplemented our IRP, and to the extent members of the public have comments on it, there's an argument, and I'm not necessarily making it because I haven't checked with my client on this issue. I wasn't prepared to speak to it, but we have filed what the public will review in terms of our IRP, and my instinct is that it's ripe for the public's review and any comment they may have. So I mean, in terms of the notice and complying with the notice, we filed our IRP. It's in the public domain now and ripe for public comment. I mean, that's my sort of gut reaction. Again, I haven't checked with my client on that particular question, but
I understand.
That's my instinct.
But without having talked to your client yet, you're of the opinion the commission perhaps should move forward with the March 18th?
I'm trying to think of, why it maybe wouldn't want to.
Well, you can file something later. Okay.
But you're right. That's what I'm suggesting.
Mr. Burns, do you have any thoughts at this time?
I'll not on this issue. I think the public certainly deserves to be heard, but I'll defer to the. No, not currently.
Thank you so much, Ms. Haskins.
SEBA has no comment on this issue.
Thank you. Thank you, Mr. Smith.
No comment. Thank you.
Thank you very much, Ms. Ariza.
I'll just add that. If the commission wants to hold the hearing in March, that's perfectly fine. Sierra Club would suggest that if that's the case, then another hearing would need to be scheduled for closer to the hearing, just so that the public has an opportunity to see what interveners are going to file, which they won't if they just get this March hearing. Thank you.
So I think what you're saying is at a minimum, the commission should schedule another customer public hearing in September, and if the commission determines in its, if in the commission's judgment it needs to also schedule the hearing in March, conduct the hearing for the public in March, you're okay with that too, Ms. Ariza? Am I?
That's right.
Okay.
Thank you.
Okay, let's see. Miss Clancy?
Yes, we agree with Sierra Club and definitely think that a public hearing, or the public hearing even, should be rescheduled to be closer to the evidentiary hearing so that customers have a chance to review a more complete docket. We don't have a problem if the commission wants to keep the March hearing on the books, but I wonder if that customer might be willing to reschedule once the commission issues a revised notice on that public hearing.
Thank you. All right, let's see. Mr. Austin, with the Office of Regulatory.
Yes, ma'am. We would defer to the commission on what to do with the March hearing. If we have it, ORS will have people available. But we do agree with Ms. Ariza that there is probably the need for a later hearing closer to the hearing with the commission for the public to weigh in and provide input.
Thank you. Mr. Walsh?
Nothing from Total. Thanks.
Thank you. Okay, Ms. Clancy, I called on you earlier. I think you're of the same opinion on behalf of Vote Solar. And Ms. Eaton?
We would agree with ORS.
Leave it in judgment of the commission. Let the commission decide.
Sure.
Okay.
And if there's an opportunity for the later public hearing closer to the evidentiary hearing, that's fine too.
Okay, thank you. Okay. Did I miss anyone? Mr. Warburn, I called on you first, didn't I?
You did.
Okay.
And like like ORS and the other party, defer to the commission on this. I mean,
Okay.
certainly, we want y'all to be comfortable with, the public's involvement, and we can issue another notice if that's what y'all decide.
Okay, wonderful. So that takes care of the customer public hearing. Ms. Moser, did you have something else regarding the schedule?
I believe we've covered everything that we had on our list.
Yes? Okay.
But I'll check with council and see if there's
Okay, well,
anything else.
while y'all are checking, Miss Purvis, Producer Purvis, would you please display this, what I have on the document camera here, the schedule? Would you mind, please? Okay, everyone. So I was trying to take some notes. I think Ms. Ariza, these notes that you see here in blue, the 9-5, and I realized Ms. Ariza also mentioned 9:23 or 9:30. So my reason for mentioning this is I think we do need to have a deadline. We all need to agree on a deadline because Duke needs at least 55 days in order to include any notice that is being sent via bill inserts to customers. So the clerk's office will need to provide Duke with at least 55 days time, a 55-day time period to issue the notice to its customers, okay? So I think we do need some type of deadline, some type of, for the schedule issue. So that then the clerk's office can issue a rescheduled notice, let the commission, if it needs to, vote on it again regarding the customer public hearing. So can we come up with will everybody work with us now to see when we can, everyone can provide his or her comments regarding this new procedural schedule, please. Now, do I have a calendar that I can display?
And we know that, this is Joanne Hill, we know that we've given y'all some things to think about with regard to by either February 7th or February 12th with regard to the additional items of whether or not in compliance with what was requested by ORS in their January, I believe, 29th letter, the 24th letter. So if ORS and Duke and whomever else is part of that discussion can provide information on the 12th, would it be reasonable that everyone can get together by maybe February 7th, which is Wednesday, which is 5 days from today, on the schedule, since we've got a 55-day window that we have to meet? So y'all can discuss any scheduling issues with the procedural schedule. And please keep in mind, whenever I make comments about not changing the hearing date, because the week of the 23rd, there is another hearing that Duke is involved in, dealing with, I believe, their fuel case. And I'm just throwing this off. I haven't talked to the clerk. Maybe that could be flip-flopped. I don't know if it could, because I know there are other timelines that are involved with the fuel case, if needed to be, or, some creativity. But please keep in mind whenever, because everybody's got an additional 300 days. But please know that the work of the commission is mostly done on the back end of everybody else's work, from what they have to do. And so that's why we are protective of the commission's time. And please know we need to build in a contingency. What if something happens and for whatever reason there's a discovery dispute and some party, whether it's Duke or another party, cannot comply with a shortened 10-day time period? So I just ask that, think about that scheduling, and if we can move a date up, like for any of the pre-filing dates that are already there, like the August 14th date, August 30th date, if any of that can be, moved up, or, to kind of accommodate everyone, to build in a buffer zone, because things happen at the last minute. We hope they don't, but if you don't plan for them, they'll happen. If you plan for them, they won't. Just some thoughts. So does it like maybe the 7th, everyone can get together and provide a report on the procedural schedule? I'll go down the list, let Mr. Wilborn go first.
Okay.
And so help me better understand what the parties are expected to discuss. My impression from earlier was that we would be discussing potential accommodations and providing discovery responses to ensure that we can meet the deadlines set by the commission in its order.
Yes, that would be part of the discussion. And then if I would say, please build in a little bit, if, think about it, whether you think you may need to build in something to accommodate for a discovery dispute. What if you can't meet the 10-day deadline or whatever the shortened response period may be? Just a thought. And if the current schedule that was part of the letter and what was adopted by the commission will not be satisfactory.
Understood.
And what I'm asking is, do y'all think y'all can all get together either, some way to come up with a report to the commission on the procedural schedule by the 7th?
You
Or
want
is
to
that
ask if anyone can't?
Yeah. There you go. That might be easier.
I can't speak as to the other party's willingness to agree to what we might propose in terms of reasonableness of discovery responses. I mean, we're, as counsel for Sierra Club pointed out, it's not just other parties that have the less than 20-day window. So all that said, we can certainly make a filing on the 7th.
Okay. And even if y'all can't come to a resolution, the commission can make the decision they can make a decision if they choose to make a decision on it. They've already made a decision so far, and they can address any discovery disputes also that come up in the future should there be a discovery dispute. So I guess what we're asking is there anyone who doesn't think that there can't be some discussion, whether you come to resolution or not? I hope you do. We all hope you do. We would all, we all want it to sprinkle wonderfulness. But does the 7th seem like something reasonable, at least to get a response back so we know where we are and if we need to have further conversation? Does anyone think they can't do that? Well, they won't know. We know you won't know a discovery dispute. Okay. What I'm saying is any dispute or disagreement or unhappiness with the current procedural schedule, which also included the offer by Duke to shorten the discovery time period. Y'all are so quiet. Did I lose anybody?
No, I think my recollection is Joanne, that if the parties are okay, as long as Duke can shorten the discovery, its responses to discovery.
And same for other parties as well, with respect to their rebuttal testimony, because it's an equally short window.
Okay.
But yes, totally agree.
Yeah, I think maybe that's why no one's saying anything.
Okay. Well, then that sounds like that's resolved. Everyone sounds like they're on a roll to shorten the discovery responses from Duke, and for dealing with the rebuttal and survey time periods, everyone's going to shorten their discovery if there's any discovery needed to be done. And
so what maybe we staff can ask the chair to place this item on the February 15th agenda, just for the customer public hearing portion. And then Mr. Welborn, if after the commissioners vote, then we will send you a revised notice for to disseminate. Y'all okay?
All right, this is Sandra again. I think we've covered pretty much everything that we intended to cover at the start of the meeting. The only other thing that that staff had been sort of contemplating is, of course, this is now 2024, and we do have a statutory obligation to have a 2024 update. So we're not making any particular suggestions about when or how we'll go about handling that, but we just wanted to float that out there as something to consider, just to keep in mind as we move forward with the IRP. Okay? So I'm not even asking for any particular comments unless anyone wants to provide any insight on that, but we obviously didn't notice that as part of the status conference. So we just wanted to make mention of that, and I think we can leave it at that.
Okay. If there's not anything else, everybody, we completed this meeting in about an hour, or this conference in about an hour. So thank you for participating. And if you have further questions for the commission, of course, I know you know how to correspond with us regarding these dockets. Hope you have a great weekend.
Thanks.
Thank you.
Thank you.